that Mr. Galbraith has 5 prior felonies and 31 prior misdemeanors. He knows well enough he shouldn't have firearms. And he just had 1 firearm. He had 6, 4 handguns, shotgun, and a rifle with ammunition.
People of the state of Michigan versus Scott Merritt Galbraith. There are 3 files, 216726, 257377, and 257378FH. Time for sentencing in all 3 files. The first file is a probation violation sentencing. The second 2 files are new sentencings. The defendant is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Burkowski. For purposes of the 21 file, the defendant, and well, actually in all files, that is, on January 26, 2026, Mr. Galbraith pled to probation violation. In 7377, he pled to possession of a weapon by a prohibited person ×2, as well as felony firearms and possession of a controlled substance. In the final file, 7378, the defendant pled to delivery of a controlled substance. Ms. Karen Eberlin has prepared the pre-sentence report for the new files. Ms. Mandy Alexander prepared the probation violation recommendation. And those were all dated, as I understand it, March 4th, 2026. Actually, the probation violation report was dated February 9th, 2026. Also, there is a prior pre-sentence investigation report from the 21 file. Mr. Rooney, if you and your client had the opportunity to review those reports.
We have.
Any additions, deletions, corrections, or objections to the report other than guidelines?
We did not object to the guidelines, Your Honor. The only corrections are on the first page of the basic information report. It asks about drug abuse, alcohol abuse, mental health treatment. They all say no on this first page, but the rest of the report clearly shows that he's had alcohol abuse problems for many years. He was attending mental health through Lisa Shadow, if you recall, a couple of years ago when we had probation violations. And the fact that he had the drug case here, I think, would indicate there's a drug abuse problem. All right. So all those should be yeses instead of nos, in my opinion. And then my client, even though the report says he's had 2 prior prison sentences, according to him, he only went to prison 1 time, and that was in 2015.
Okay. Mr. Burkowski, any comment relative to correction of the report relative to the controlled substance issue?
That Mr. Rooney brought up?
Yes, sir.
We leave it to the court's discretion.
All right.
I did have something for the court, though.
Go ahead, please.
Your Honor, I've talked to Ms. Eberline about this. So in the jail credit, it says for file 7377, 7 days credit. So as it relates to that file, count 1 and count 2, either way, you know, he either gets credit on one of those counts, and the other one he would not get credit for. Usually the felony firearm would have the credit because that's the first sentence we serve. So then count 1 would have 0 credit. But as it relates to the other docket, which is 7378, it says 0 days credit. And Ms. Eberline and myself have talked about that. I believe the way that the statute reads, he should be entitled to 7 days credit for that count.
You agree, Ms. Eberline?
Yes, Your Honor. Your Honor, can I also add regarding the substance abuse, if you look at page 2, and it says substance abuse history, it says yes.
Yeah. Yeah, I think the bulk of the report
Says yes.
Yeah, but it was just on page 1. I can show you.
Okay. Yeah, I'm not sure why that's coming up on BIR. Yeah. Computer. Okay. Thank you.
All right. Those changes will be made. I'm assuming, Mr. Rooney, you have no objection to 7 days credit in the 7378 file. Understandable. Okay. Any comment relative to the comments of Mr. Rakowski pertaining to 7 days credit pertaining to 7377?
No.
Okay. And my copy indicates 0 days credit in counts 1, 2, and 3, but 7 days credit in count 4, which I think Mr. Rakowski was stating as well. Okay. Anything else regarding the report? Mr. Rooney,
No, Your Honor.
any guideline issues? Again, I just want to make sure. And Mr. Galbraith, you agree with all that?
Yes, sir.
Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor.
Mr. Rooney, what would you like to say on behalf of your client before the court imposes a sentence?
Your Honor, my client is now 55. For many years, he's been a highly skilled flooring contractor here in our county. Worked in my home on a couple of different occasions for me over the years. I trusted him, even though I knew about his background. I trusted him to work at my house while my family was gone. I had no issues with him being in my home doing work, not worried about him stealing anything or anything like that. As far as the underlying charges, the reason my client states that he had those firearms in his possession rather than with his mother, who was the registered owner of most of them, I believe, was that his son, who was having some mental health problems, was going to be living with his mother. They were worried about that son using guns perhaps for suicide or something. So looking back, he should have made other arrangements for those guns other than taking them to his house, but he was doing what he thought was the lesser of two evils at the time. And then as far as the controlled substance deliveries, according to my client, that the CI was a friend of his who we had known for some time in the construction world. And this friend had told Scott that his prescription had been reduced by his doctor and he was having pain. Like even Scott, carpet laying and flooring is really bad on your body.
Primarily your knees and your back.
So he thought he was helping this friend by giving him or selling to him his deceased relatives' leftover supply. Again, that was a bad decision. He's not a doctor, he's not a pharmacist, but at the time he thought he was helping this friend who turned out to be a confidential informant. As far as the recommendations, my client is beside himself today, having to go back to prison. He's asking that you not impose the 2-year mandatory minimum, or if you do, that the other charges will run concurrent with that. It's this practitioner's opinion that that is not feasible. The law says mandatory minimum, so I don't think you can do that, but he asked me to ask you to do that anyway. Does acknowledge that he made some mistakes that are crimes and that he has to be held accountable for his actions. And if you recall, he did plead guilty to virtually everything that was charged against him. I would point out that even if you did send him for the 2-year mandatory minimum, and if you did the minimum of, or the maximum of the other 3, he'd end up with 3.5 because it's an 18-month for the probation violation. So in my mind, the least I can ask for is the 3.5. That's what I'm asking for respectfully. I and my client do appreciate the probation officer's recommendations that all the other counts would run concurrent, which helps out on this maximum here, other than the felony fire. But as I was explaining to Mr. Galbraith, the math is what the math is. I can't really argue for less than the absolute minimum, which I believe is the 3.5. So that's what I'm asking for. He has been working. I mean, he was doing the carpet laying and flooring for years, and I think he switched and went to work in a factory for the last couple of months. So he was working in the community as a wife, as a child. Unfortunate, but that's what we're asking.
Also, is there any objection to one pre-sentence report covering the two newest files?
No, Your Honor.
Did your client wish to address the court? Mr. Galbraith, go ahead, sir.
Why was it a tough one? I'm by addiction. Trying to help my kids. I'm a father. I'm a husband. Fire. Did do the right things. Trying to protect my family. Loads of stuff I wasn't gonna keep them. All this stems down from one probation violation that I got. Driving. 120. Scared of the future. I'm sorry, I'm trying to fight addiction. Doing the best I can.
Anything else, sir?
I have failed tests, I know that. Just. I look, it's a God's answer.
Anything else, sir? Mr. Rakowski, anything on behalf of the people?
We point out to the court that Mr. Galbraith has 5 prior felonies and 31 prior misdemeanors. He knows well enough he shouldn't have firearms. And he didn't have 1 firearm, he had 6, 4 handguns, shotgun, and a rifle with ammunition. And he knows he's not supposed to possess that. Department of Corrections did their compliance check, found that he was not in compliance. And to top things off, Your Honor, he's on probation at the time. And besides that one, there were the controlled buys that were done. He pled to 1 of them. There was 2 of them in total. And he's also on probation. I heard the explanation, but he's on probation. He knows better than that, and yet he still commits these crimes. Your Honor, we're asking you adopt the recommendations that set forth that he be sentenced on the felon in possession by a prohibited person to the 24 months mandatory, the felony firearm mandatory with 7 days credit for that one. And then for the other count, the recommended 24 months, and that is going to run consecutive to that with no credit.
Thank you. This was Nighthawk, was it not?
Yes, sir.
I can't stress enough, it's a new day in Huron County. It has been for a couple of years now with the Nighthawk program. This is a Department of Corrections program. When individuals are placed on probation, it's been, at least from my experience in the past, across the state, frankly, when I practiced across the state, that people placed on probation are placed on probation. They report to the probation agent, and they're not looked upon in a surprise situation. In other words, when you schedule your meeting with the probation agent, you meet with the agent, you report to the agent, that's all, and you're done. The Nighthawk program is a completely different program. Department of Corrections individuals will come to your house when you least expect it, and when they show up, they have the right to search the home, premises, computer, everything, vehicles, to make sure individuals are compliant. And we've had a number of cases come before this court, including this one, where an individual is merely on probation for operating while intoxicated third offense, and they're in possession of firearms or ammunition. And the court every time will tell the individual who's on probation, to be placed on probation, you are not to possess a firearm. Period. On top of that, individuals who have prior felonies know that as well. Once you're a felon, unless your rights have been restored, you do not get the right to possess a firearm. And that's what happened here. Not 1, but Mr. Rakowski, 6.
Yes, sir.
6 firearms. And the explanation is, well, I'm concerned about my son. And the court appreciates that. I'm not discounting that, Mr. Galbraith, at all. But they can't be in your possession, in your home. There are other avenues. Easy, easy for the court to say no. I mean, we're armchair quarterbacking this, Monday morning quarterbacking this, essentially. But there's a proper way to do it. Sadly, you didn't do that. On top of that, you fell upon maybe the weakness of another individual in controlled buys and you delivered a controlled substance. I'm not considering the other alleged incident. I'm only considering the one you pled to. That's all the court can consider. But when you're 55 with 5 prior felonies, 31 prior misdemeanors, I think you kind of understand what you have to do. And sadly, you didn't. And you have to be held accountable for that. So it will be the sentence of this court. And this is under statute. This is mandatory. This is file 7377. I'll begin with count 4. The defendant is committed to the Michigan Corrections Commission and placed in their custody for a period of 2 years, flat. Credit for 7 days previously served. $68 in state costs will be ordered. In count 1, count 2, and count 3, it will be the sentence of the court that the defendant be committed to the Michigan Corrections Commission, placed in the commission's custody for a period of not less than 2 years to 10 years. Actually, that's counts 1 and 2. 2 years to 10 years. No credit for time served. In count 1, $130 for crime victims assessment. Court's waiving attorney fees. $68 in state costs will be ordered in count 1 and count 2. And in count 1, all firearms and ammunition seized by police will be forfeited to the investigative agency for disposition. That would be counts 1 and 2. Count 3, committed to the Michigan Corrections Commission for a period of 24 months to a maximum of 8 years. Again, credit for 0 days served, $68 in state cost in that count as well. Counts 1, 2, and 3 will be served consecutively to count 4. And that's by law. In 7378, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission, placed in their custody for a period of not less than 24 months to a maximum of 40 years. Credit for 7 days previously served. He's to pay restitution, the amount of $480 to the Bad Axe Police Department to execute a wage assignment to pay that restitution if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. Attorney fees are waived. $68 in state costs will be ordered. 7378 shall run consecutive to count 4 in 7377, but concurrent to 7377 counts 1, 2, 3. We did due date 2.
May 18th.
All financial obligations are due May 18, 2026. Court finds good cause. Defendant is unable to pay at this time based upon his sentence, and then the 20% late penalty will apply. In file 216726, it will be the sentence of this court that the defendant be placed in custody of Michigan Department of Corrections for a period of not less than 18 months to 7.5 years, credit for 218 days. He's unsuccessfully discharged from probation. All monetary obligations remain collectible. This sentence shall be served concurrently with all the other files except for count 4, which is the felony firearms count. It must be served consecutively. Again, May 18, 2026 would be the due date. Anything that was missed, Ms. Everly? All right. It's my duty to inform the defendant he has right to seek leave to appeal If he's financially unable to provide counsel of his own choice, court will assign counsel from the public expense. He's to initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days.